Yeah. Never read.
All rise. 14A District Court for County of Washington, State of Michigan, now back in session. The Honorable Judge Day, Cedric, preside.
May be seated. It's an arraignment. Arraignment on a bench warrant. Court does call the case State of Michigan versus Alan Roger Barnes. Barnes, oh, still. Who's my press?
Peter Phil is appearing on behalf.
Oh, there she is.
I'm sorry. First, Assistant Public Defender Kalina Anderson with on behalf of Mr. Barnes.
I apologize, Your Honor. Gabrielle Ragland on behalf of the people.
That's okay. I recognized you. No, I'm kidding. Had to throw that out there. All right. Mr. Barnes? He's still muted, right? Can you get somebody to unmute you, Mr. Barnes? Got it. They got it. Can you state your name, sir?
Alan Roger Barnes.
Thank you. All right. This is already a PD case. Go ahead, Ms.
Thank you, Your
Anderson.
Honor. I show this as a bench warrant for a failure to appear at the looks like final settlement conference on December 3rd. In speaking with Mr. Burns, he advised that he tried to log into the Zoom hearing. He was never let in. He later found out that the hearing was in person. He was unaware of that at the time. He now understands that those hearings are in person and he needs to appear and will certainly do so. He's a father of 4 and lives in Ypsilanti. He's asking for the court's consideration of recalling the bench warrant, granting him a personal bond, and resetting the matter for final settlement conference.
Any response from the people?
No, Your Honor. People have no objection.
All right. Bench, I'll cancel the bench warrant. Pretrial in this matter. Yes, he's been arraigned. Pretrial in this matter will be set for
April 15th at 8:30.
April 15th, 2026, 8:30 for Judge Barr. Previous bond is reinstated.
Thank you.
Thank you.
Thank you.
All right. Thank you, sir. I'm going to sort of intersperse some of what I've got with those arraignments. So folks, this is court calls the case People versus Matthew Gale.
Ready, Your Honor.
Ellison on behalf of Peter.
Your Honor, Joe Simon on behalf of Mr. Gale. Mr. Gale, state your name when you get up here.
Matthew Gale. Nice.
Your Honor,
But your same height. Joe.
oh, man, I always,
And you know, I really didn't have to say anything, but I did.
I always condition my clients, be ready, here it comes. But yes, Your Honor, as my father say, life is too short and so are you. But anyway, back to that, Your Honor, Ms. Zenda got the missing discovery to me about a half hour ago.
Oh,
So we are ready to schedule the matter for preliminary exam.
that was being her laughter. Right. So you have everything.
Well, I'm told it's my Ms. Yu has informed me it has been received.
All right. People have their witnesses available the 7th.
We'll start with Your Honor.
Preliminary examination in person, April 7th, 2026, 9 a.m. before me. Bond will continue. No, when he shows up. You're all right.
All right, we'll see. Don't have to-
So that's it.
Yes, sir.
Felony arraignment. Court calls the case of People versus Derek Miller. Mr.
Good
Miller?
afternoon. Go ahead.
Sir? Oh, go ahead, Madam Prosecutor. I'm sorry.
Good afternoon, Your Honor. Gabrielle Ragland on behalf of the people.
All right, Mr. Miller,
Yes, sir.
state your name.
I'm Derek Miller.
All right. Mr. Miller, you're before the court on a 1-count felony complaint that alleges that on or about September 28, 2025, at the location of 650 South Forest, that you did commit the offense of malicious destruction of personal property, $1,000 or more, but less than 20,000. You understand the nature of that charge, sir?
Yes, sir.
All right, that's a felony punishable by up to 5 years incarceration, or $10,000 fine plus court costs. Fine could be increased if 3 times the value of the property. If that's greater than $10,000, that becomes the maximum fine. You understand that?
Yes, sir.
All right, my first question to you is, do you want to be represented by an attorney?
Yeah.
Okay. This is a public defender case.
First Assistant Public Defender Kalina Anderson with and on behalf of Mr. Miller. You're going to waive any further reading, stand mute, and reserve the bond argument.
All right, defendant having waived formal reading, standing mute. Court will enter not guilty plea. I will set probable cause conference in this case for April 2nd, 2026, 9 a.m. as to bond.
Thank you, Your Honor. The people are not requesting a financial component in this case. We are requesting standard felony conditions along with no go to any, I believe it's PCI parking structures in Ann Arbor.
PCI.
Yes.
And parking structure. Those are probably the ones that don't fit my truck. Anyway, never mind. All right. Ms. Anderson.
Thank you, Your Honor. There's no objection to that request, that bond condition. My client lives in Milan. He has a full-time job and has held that job in construction for about 2 years. There's nothing else holding him in custody. He's not currently on probation or parole. We would ask the court for a personal bond pending the PCC date.
All right. Set the defendant's bond at a personal recognizance $5,000 bond, all other standard conditions, including no assault behavior or possession of any weapons. You understand that, young man?
Yes, sir.
And also there's to be no possession or consumption of any alcohol, recreational marijuana, or illegal drugs. And you're not to go to any PCI parking structure. You understand that?
Yes, sir.
All right. Thank you. Court calls case People versus John Lenz.
Your Honor. Alex Jablowski to the people, Your Honor.
Your Honor, Joe Simon on behalf of Mr. Lenz. State your name, John.
John Lenz.
Thank you.
Your Honor, you should have a green sheet in front of you. Mr. Lenz is being screened for sobriety court by Mr. Heaton in the 14A court, the 30th. And we're asking for the next available PCC after that because we expect we will resolve our case that day.
All right. So the 7th, or not, I'm sorry, the 2nd.
I'll be here if you.
That'd be enough time, you think? And
I think so. I think my client's already done so many things proactively. I think this is going to be a quick decision by Mr. Heaton.
all right. April 2nd, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Here.
I have to.
Court does call the case of the people versus Joseph Tinderington.
Alex Jablowski to the people.
I probably not.
And Your Honor, Joe Simon on behalf of Mr. Titterington.
Yes, I put an ad in.
Your Honor, in this
His name, sir?
oops,
Joseph Titterington.
Thank you.
in this case, there's some continuing negotiation. We also are asking for an adjournment of the P.
Getting smaller. I mean, all of your clients seem to be, never mind. Go ahead. I'm sorry. It was just,
I think it's fair to say that's the long and the short of it.
it was just an observation. Go ahead.
Actually, it might be true as we advance in years. It could happen. But anyway, back to the point. We do want to adjourn the PCC for continuing negotiations, but we don't need to hurry on this one as much because I think there's going to be more that needs to be found out.
16th or 23rd, which one looks better?
Jablowski, I'll defer to you.
Whatever works for your schedule.
16th will be fine.
April 16th, 2026, 9 a.m. bond continued.
Thank you, Your Honor.
Thank you. You have somebody up at the chair?
You don't wait for me unless you.
Court calls the case versus Alexander Sanchez Garcia. Is
Good afternoon, Your Honor. Jacob Keenan on behalf of the people.
that it for you, Mr. Sun?
Yes, Your Honor, that's about all the juice I can take. Thank you.
Wow.
Good afternoon, Your Honor. Nicholas Monterez, on behalf of Mr. Alexander Sanchez Garcia, present to my right. Can you state your full name for the record, please?
Alexander Sanchez Garcia.
And you see me in adjournment.
And this will be a final adjournment, Your Honor. The people have made a very gracious offer. Mr. Sanchez Garcia just needs some time to consider that. We're asking for 2 weeks if the court will allow.
Probable cause conference, April 9th, 2026, 9 a.m.
Thank you, Your Honor.
Your Honor, I apologize, Mr. Kennedy, Your Honor, and if I could just quickly on bond. Thank you very much. I did speak with the people. Mr. Sanchez Garcia has asked that I make the request that he be able to travel to Chicago to visit family and attend a soccer game. He'd be leaving this coming Sunday, the 31st, and returning on Wednesday, the 31st, and returning on Wednesday, the 1st.
Just one day.
No, I apologize, Your Honor, the 29th to the 1st.
Okay, all
My
right.
date
So
is up there.
going from Sunday, returning Wednesday.
That's correct, Your Honor.
Right? Okay. Any objection from the people?
No.
All right, defendant may travel to Chicago 29th through the 1st. That includes your travel days back and forth, correct? All right. Okay, I'll through.
Thank you, Your Honor.
All right, thank you.
Thank you, Your Honor.
Court does call the case of People versus John Mulder.
Oh,
Hello. State their appearance. Oh, there she is.
Gabrielle Ragland on behalf of the people.
versus
All right,
John
sir.
Robert Mulder, Mulder.
All right, thank you, sir. Sir, you are before the court on a 5-count complaint that alleges that on or about March 25th, 2026, at the location of 312 West Huron Street in the city of Ann Arbor, count 1, count 2, count 3, count 4, count 5, actually, all of them. Well, let me do it this way. Count 1 is that you did resist, obstruct, or oppose a police officer or first responder and caused injury. You understand that charge, sir?
Resisting and obstructing.
Yes, but you caused injury. You understand that?
I didn't
Or it's
know
a
that.
Pardon?
I didn't even know that.
Okay, but you understand what you're charged with?
Resisting and obstructing,
Yes,
which is
but
no
causing
different.
in. Okay, that's
No different
sir,
than if I
I
assaulted the
just need
police
you to.
officer.
I just need you to understand what you're charged with.
Resisting and obstructing.
Yes. R&O. You have 4 counts of just straight R&O, and those are basically
Where's my
felonies
lawyer?
punished up to 2 years, $2,000 fine plus court costs. You
Where's my
understand
lawyer?
all of that? Pardon?
Where's my lawyer?
When is your warrant?
No, where is my attorney? Counselor.
Your attorney is here. I'm trying to make sure you understand what you're charged with, sir.
I don't see him.
Okay, it's a her. And
Her.
do you want to be represented by an attorney? We'll just skip this step. You want to be represented by an attorney?
Well, yeah.
Okay, Miss Anderson, go ahead. This is a PD case.
Miss
Thank you, Your Honor.
Anderson.
First Assistant Public Defender Kalina Anderson with and on behalf of Mr. Mulder. Your Honor, did you have 2 cases for Mr. Mulder or just the one?
I just have one.
Okay,
Yes.
Your Honor, we waive further reading at this time, stand mute and reserve the bond argument.
Defendant every way formal reading, standing mute. Court will enter a not guilty plea. Probable cause conference in this matter will be set for April 2nd, 2026, 9 a.m. People as to bond.
Thank you, Your Honor. Gabrielle Ragland on behalf of the people. As to bond, the people were anticipating both matters going today, but I will speak to the current matter. The people are requesting a financial component in this case. We are requesting a bond in the amount of $10,000, and that is due to 1, the nature of the allegations. 2, there is an allegation that there was possible substance abuse. And 3, this is there was an outstanding warrant at the time of this offense, and there had already been a previous RNO the week before. That was the other case I had hoped gone through by now, but I don't believe it has. So the people are also requesting, in addition to that bond, substance abuse testing for methamphetamines and standard felony conditions.
All right.
Response.
Thank you, Your Honor. There's no objection to the standard conditions. However, we would ask for a personal bond in this case. There's nothing else holding Mr. Mulder in custody at this time. He's here locally and has ties to the community. He will appear for all subsequent court dates and remain in contact with counsel throughout the pendency of this case. We'd ask for a PR bond pending the PCC.
All right.
I need a primary care PCP. I don't even know
Right.
what my PCP is.
Your PCC is set for April 2nd.
No, I don't even know who my PCP is.
Okay, I got you.
Primary care
What
physician.
I'm gonna do is I'm gonna set the defendant's bond at a $5,000 cash security bond. I'm gonna order standard conditions, including no assaultive behavior or possession of any weapons or ammunition or anything fashioned to be a weapon. No
Lawyer,
use of alcohol, recreational
Attorney.
marijuana, or illegal drugs.
counsel,
Full order
Counsel.
community corrections, testing for intensive supervision. I will also indicate that if the defendant is released, he is to be placed on a GPS tether. And that with that GPS tether, I'll just make it location tracking. But I would indicate that the defendant is not to go to the Ann Arbor Police Department on, and let me get their address. I just had it. Not to go to the Ann Arbor Police Department at 301 East Huron Street in the city of Ann Arbor. He is also not to have contact with the following individuals. That'd be Matthew Core, Melissa Downer, Matthew Coles, Alexandra Van LaValle, and Eric Schultz. All right, thank you. You're all set, sir. Thank you. Court does call the case. People versus Derek Barron.
Good afternoon, Your Honor. Kristen Lewis Perez, requesting permission to practice under Michigan Court Rule 120 under the supervision of Assistant Prosecuting Attorney Ali Zedek.
Hold it. You've been sitting there all day and that's it. How come they wouldn't let you play earlier?
Picking on me.
John. What?
But
How come? She did a fine job the last time and you all. Well, in there all morning, just sitting there. I'm solemn, thinking like, well, so she said. All right, permission to practice is granted. All right, East Hope.
Chris Easthope on Chris Easthope on behalf of with Derek Barron, Mr. Barron, just state your name.
Derek Barron.
You're about the same.
I would have brought a stool to stand.
Okay. All right, what are we doing?
We're asking this to be set for an exam, Your Honor. Ms. Zenda and I have talked about April 21st, is that right?
yes,
Oh, I'm sorry.
that's
Whoa, you just flew right back.
Well, because you made,
Sorry, that was
Full
so
time.
rude.
Mr. Perez, they made it.
21st. So you have all discovery.
Except for, didn't I ask for, there was, one of the pictures we were talking about, you're gonna send me. We'll have them by that time, Your Honor.
You'll have it.
That's the
Okay.
It would hold us up for the exam.
All right, well, but what is it that, because you won't be,
So I asked for a date stamp on a photo, not just
it's a
it's a photo and you need to date stamp the metadata from that.
photo. We see the photo with the date stamp on it. Now it's
correct.
All right. And you would have your witnesses available the 21st?
correct.
Preliminary examination in this matter in person will be set April 21st, 2026, 9 a.m. before Judge Garwood. bond with its conditions will continue. Thank you.
Your Honor.
You did a wonderful job.
Try my best.
And it did today. You think? Okay.
Good news is it's still last in custody.
It is.
Yeah, he's got two students with two different dates. Two felony,
Got it.
a bond violation, one felony, and one misdemeanor.
Okay. Don't know why.
Yeah.
All right. Court does call the cases of the People versus Daniel Haynes. Prosecutor, state your appearance.
Good afternoon, Your Honor. Gabrielle Ragland on behalf of the people.
And I think these are all public defender cases.
Thank you, Your Honor. First Assistant Public Defender Cleena Anderson with and on behalf of Mr. Haynes in all matters.
All right. He has, and let's try to deal with the misdemeanor ones first. He has two. These are both bar. I have a 221.
Because it's a township.
Got it. Okay. Okay. So I have two misdemeanor cases before Judge Barr. One larceny less than 200, as well as the breaking and entering, which have their bench warrants and the failure to appear, it looks like in November of last year. Do you want to address that?
Thank you, Your Honor. With regards to bond, there's no excuse for him missing the court dates. He accepts responsibility for that and is extremely remorseful for that. There's nothing else holding him in custody at this time. I do see one of the cases, I believe, also had a bond violation, the 1337 matter. And I believe bond was denied in that case. He's asking for the court's consideration to allow him a personal bond on all of these matters and to reset the pretrials and the misdemeanor and the PCCs on the felony case.
All right. Anything from the people?
Nothing from the people.
All right. On the two misdemeanor cases, I'll set his bond at $1,000 with a 10% privilege on each case. I will set pretrial in these matters. Well, he's going to get two pretrial dates. So on the breaking and entering pretrial, April 15th, 2026 at 8:30. All right, and I will recall the warrant on that case. On the other matter, we'll do the same, recall the warrant, bond 1,000, 10% on that. We'll recall the warrant, and pretrial on that matter will be
April 21st at 8:30.
April 21st, 2026 at 8:30 before Judge Barr. On his, let's go with the other Ypsilanti case, which is going to be 23F20364. Got a failure to appear on that one. On that one, I will set the defendant's bond at $10,000. I'll give a 10% privilege on that. I'll set his, he was set for probable cause. I'll set his probable cause for April 2nd, 2026, 9 a.m. All right. And his previous conditions are reinstated. And this one, was he denied in this one?
It is.
It is. In the case, yeah, I see. 22FB 1337, I will set his bond at a $50,000 cash surety bond. There is a potential violation in that case. I will set a probable cause hearing in that case for April 2nd, 2026, 9 a.m. Unless you want Ms. Anderson to have the hearing on the case at that time, I'll set it at 3 p.m.
Your Honor, I believe 9 o'clock is fine for now.
That's right. Okay, very good.
Thank you.
We'll set it. Thank you. I think that's it.
That's it.
That's it for you guys.
Thank you, Your Honor.
Thank
Have a
you.
good rest of your afternoon.
It was a wonderful job I did.
You
It
did.
was. Thank you.
Take care. Court does call the case, People versus Andrea Aker.
Carolyn Foster Tucker on behalf of Andrea Aker.
Andrea Aker.
All right. I have before me a plea form that indicates that the defendant will be pleading to guilty to an added count 2 of use of cocaine, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That is correct, Your Honor.
All right, may I have her sworn?
The right hand. From the firm, the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes,
State your name, please.
Andrea Aker.
Ma'am, it is this court's understanding that you were going to be pleading guilty to the charge of use of cocaine. That is a misdemeanor punishable by up to 1 year incarceration, $1,000 fine plus court costs. You understand that?
Yes,
Understanding that, you still wish to plead guilty?
yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand by pleading guilty, you'll not have a trial of any kind.
Yes,
You signed an advice of rights form, is that correct?
yes,
Any question regarding any of those rights?
no,
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
yes,
You understand you're giving up your right to appeal of rights.
yes,
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
no,
Anybody threaten you or coerce?
no.
You're doing this voluntarily and of your own free will?
I'm sorry, say again?
You're doing it voluntarily and of your own free will?
Oh,
And also because you believe that you are indeed guilty of this offense?
yes,
On the date of June 15, 2024, at US 23 near Washtenaw, Pittsfield Township, Washtenaw County, State of Michigan, did you have cocaine in your possession?
yes,
Had you used it?
yes,
You know what you were using was cocaine.
yes,
All right. Ma'am, I do have to advise you that if between the time I accept your plea and your time of sentencing, if you commit misconduct as defined in the Michigan court rules, you would not be entitled to withdraw your plea and the court would not be bound by any sentence recommendation or evaluation. You understand that?
yes.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
Oh, Your Honor.
No, Your Honor.
And have I complied with the quote?
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1. Sentencing in this matter will be
April 29th at 12 noon.
April 29, 2026, 12 noon, before me. Bond will continue. All right, thank you. Ma'am, on your way out, probation will be on your left-hand side, about 2 feet way down.
Okay.
Stop it, please.
Thank you, Your Honor.
Thank you. Court does call the case, the People versus Cameron, is it McCrate?
Yes, sir,
Good.
McCray.
Good afternoon, Your Honor. Alex Chavalowski, People.
Carolyn Foster Tucker on behalf of Cameron McCray.
Ma'am, state your name, please.
Cameron McCray.
Thank you. You're requesting an adjournment.
Yes, Your Honor, I do believe we are close to a resolution.
Found the paper. Sixteenth or 9th, which would you prefer?
Do you have a preference? The 9th is fine.
All right. Matter will be adjourned April 9th, 2026, 9 a.m. Bond continued. All right,
Thank you,
thank
Your
you.
Honor.
Thank you.
You're welcome. Court calls the case, People versus Hunter, is it Heartline? Heartline?
Hurt line.
Alex Chavalowski, the People.
And good afternoon, Your Honor. Megan Stamel on behalf of Mr. Hertline, who is present on Zoom. I'll ask Mr. Hertline to state his name for the record as well.
Hunter Hurtline.
Thank you. All right, what are we doing?
Your Honor, I've been in contact with the assistant prosecutor on this case. We have had a couple adjournments already, but I think we are close to reaching a resolution. I don't know if the court would entertain one final adjournment.
I will.
Thank
Probable
you.
cause conference in this case, April 9th work for you, counsel?
I may have one moment. Yes, April 9th would work, Your Honor.
April 9th, 2026, set it at 9 a.m. You'll get an invite with your time block. It'll usually be in the afternoon.
Yes, Your Honor. Thank you.
Right, bond will continue. Thank you. Court does call the case of the people versus Daquan Mallet.
Alex Jablowski.
Good afternoon, Judge. On behalf of Mr. Mallet, Attorney Nicholas North, PH 6482. Mr. Mallet, if you could please unmute and state your full name for the record.
Daquan Mallet.
Thank you. All right, what are we doing? Hey, don't everybody speak if I want.
Judge, I was emailed and asked for an adjournment, so I'm guessing that's what we're doing.
Okay. All right. You want the 9th or the 16th?
The 9th works fine for me.
All right. Probable cause conference will be adjourned April 9th, 2026, 9 a.m. Bond will continue. Thank you.
And Your Honor, just to ask, do I need to fill out the Zoom form again to come on Zoom? Just making sure.
Yes, sir.
Okay.
Yes, sir.
All right, thank you.
All right. Thank you. Court calls case people versus Jennifer McCready.
Alex Jablowski.
Your Honor, hello, good afternoon. Matthew Mansour on behalf of Miss Jennifer McCready, who appears via Zoom. Jennifer, can you please unmute, state your name, put your camera on for Judge Simpson?
There we go. Jennifer McCready.
Still need a camera. We got you. Okay, there. All right, what are we doing on this case?
Your Honor, this is our second PCC. I'm still gathering mitigation information. I'm trying to come up with a resolution. If I could request another adjournment from you, please.
No objection.
Okay.
Probable cause conference will be adjourned to April 16th, 2026, 9 a.m. Bond continued.
Thank you.
All right. Thank you.
Thanks, Your Honor.
Court calls case people versus Derek Smith.
Afternoon, Your Honor. Arraignment to cook with people.
And good afternoon, Your Honor. Uwe Dahl Smith on behalf of Mr. Smith, standing to my right there. Please state your name to the court. Your Honor. My name is Derek Smith.
Thank you.
We are at a point where to set this for exams. April 7th, I understand.
Discovery is complete.
I'm sorry?
Discovery is complete.
Yes, it is.
People have their witnesses available the 7th.
Yes, sir.
Preliminary examination in person will be set April 7th, 2026, 9 a.m. before Judge Perry. Bond will continue.
Very good. Thank you.
Thank you. Court does call the case of the people versus Denzel Evans.
Alex Jablowski for the people, Your Honor.
Here we go. I'm here, Your Honor. Sheldon Kay on behalf of Denzel Evans. He's right over here.
All right. State your name, sir.
Denzel Evans.
Thank you. All right. I have before me a plea form. Is that what we're doing today?
Yes, Your Honor.
All right. The plea form indicates that the defendant will be pleading guilty to the charge of disturbing the peace, the 90-day offense. Upon a successful plea to that charge, count 1 would be dismissed. The defendant is also agreeing to pay $4,200 in restitution. And also there is a sentence agreement between the parties to sentencing under the prosecutor's deferred program. That is the court's full understanding of the agreement. Is that correct, counsel?
Yes, Your Honor.
All right, very good. Mr. Evans?
Yes.
Please raise your right hand to be sworn, sir. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, state your name again, sir.
Denzel Evans.
All right, sir. It's court's understanding that you're going to be pleading guilty to the charge of disturbing the peace. That's a misdemeanor, punishable by up to 90 days in jail, $500 fine plus court cost. Do you understand that?
Yes.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge in this case, and that you would be sentenced before Judge Washington in the 14B District Court. You understand that?
Yes.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No, sir.
You understand that you're waiving all of those rights, including the rights contained in paragraph 5, which are your trial rights.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you are indeed guilty of this offense?
Yes.
On the date, or between September 9th, 2024 and October 9th, 2024 at the location of 2085 East Michigan Avenue, Ypsilanti Township, Washtenaw County, State of Michigan. Yes, what do you do that makes you think you disturbed the peace? Or counsel, you may inquire of you.
Yeah, thank you, Your Honor. Okay. The date that you were arrested what date was that, Mr. Evans?
January 22nd,
Tell the court of what year?
2024.
Tell the,
No, 2026, I'm sorry.
so was this year?
Yes.
Okay. Tell us what happened when you were arrested in the evening.
I was getting my house, I was shutting down my house and I noticed flashlights outside. I go to the front door, seeing that it was police officers out there. I asked what was going on. They said my car was involved in a hit and run, and to ask me where was I at, and I told him I've been home for the last few hours. He asked me for my ID. My ID was in the car, so he asked me to go out to my car to get my ID. And once I got on the porch, him and a few other officers put me in handcuffs and started telling me to put my hands behind my back. And I got loud and I was asking what was going on, why you arresting me.
Did you disturb your neighbors?
Yes, and my neighbors came. My next door neighbor came out to the front porch.
Did you use foul language to the police?
Yes.
Okay. No further questions.
All right. Sir, I do have to advise you that if I accept your plea, that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation or evaluation. You understand that?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor. Thank you.
And have I complied with the court?
Yes, you have, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing will be May 7th, 2026, 10 a.m. That is before Judge Washington.
Thank you very much, Your Honor.
Bond will continue.
Thank you.
All right. Take care.
Take care, Judge. Bye-bye.
Court calls the case People versus Calvin Cannon.
Good afternoon, Your Honor. Deborah Schlossel, P56420, on behalf of the defendant, Mr. Calvin Cannon. Mr. Cannon, please state your name.
Calvin Cannon.
All
Your
right,
Honor,
what are we doing?
Your Honor, we would like to set this matter for exam.
All right.
Thank you.
Discovery is complete.
Yes, we have it all.
All right. People have their witnesses available April 7th. All right. Set preliminary examination, April 7th, 2026, 9 a.m. That is before me. That's an in-person proceeding.
Your Honor, I do have one request. I know the victim is not on the Zoom today, but it's my understanding she's sick, but that she was in contact with the prosecution and wanted the no contact order lifted. I don't know if the prosecution can confirm that or if that matters to you.
At this time, we do not want to.
At this time, they're objecting to the lifting of that order. I'm not going to do that until I can hear from the alleged victim.
Okay. Get confirmation from the victim that that's what she wanted, probably we would have tried, and she's not present.
Got it. I think, I understood what we were doing here, and I'm not going to order that, and certainly would not order it without hearing from her. All right.
Thank you, Your Honor.
All right. Thank you.
Thank you. Have a good one.
You do the same. So she got to do 2 cases? Not that we're counting. I'm just saying, and this is the funny thing about it. When Zenda was here, as in that, she was like all over the dock. Like you couldn't keep, I'm just saying, it's things change when all of a sudden the pupil becomes the teacher. All right. Court calls the case of the state of Michigan versus Stephen Yenny.
And so this is how we have the people.
And good afternoon, Your Honor. Joshua Nushin, I'm here on behalf of Stephen Yeaney. We appear by Zoom today.
Yes.
Mr.
All
Yeaney,
right.
can you put your name on the record and turn your camera on?
Yes, Stephen Yeaney.
All right. I have before me a plea form. Plea form indicates that the defendant will be pleading guilty to the charge of refusal to obey a traffic order, the 90-day offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's correct, Your Honor.
That's correct.
All right. Jenny, can you raise your right hand, please, sir?
Yes, sir.
Solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
All right. State your name again for the record, please.
Stephen Yeaney.
All right. Sir, it is this court's understanding you're going to be pleading guilty to the charge of refusal to obey a traffic order. That is a misdemeanor punishable by up to 90 days and $100 fine plus court costs. You understand that, sir?
Yes, Your Honor.
You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced to be Judge 18B District Court. You understand that?
Yes, Your Honor.
All right. Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
I did.
Any questions regarding any of those rights?
No, sir.
You understand that you're waiving or giving up all of those rights contained on that form?
Yes, sir.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you are indeed guilty?
Yes.
November 2nd, 2025, at the location of March Road near Bunton Road, Ypsilanti Township, Washtenaw County, State of Michigan. Were you in a motor vehicle?
Yes.
Did the police give some hand signal, voice signal, or turn on their emergency lights indicating that you should do something?
Yes, sir.
All right. Which one did they do? Lights?
Yes, sir.
Lights and sirens?
Yeah.
And you were supposed to pull over and you didn't?
Yeah. Yes, sir.
Yeah?
Yes,
Okay.
sir.
And you knew that those were police officers behind you giving you a signal to pull over?
Yes, Your Honor.
All right. Sir, if I accept your plea, I have to advise you that between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct that's defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation or evaluation.
Yes, Your Honor.
You understand that, sir?
Yes, sir.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
Have I complied with the court rule?
People are satisfied.
You have, Your Honor.
Court will accept the defendant's plea of guilty to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 14B. Probation sentencing will be
May 7th at 10 a.m.
May 7th, 2026, 10 a.m. before Judge Washington.
Your Honor, can I move that date? I'm at MATCP, the Michigan Association of Treatment Court Professionals, the conference that we.
I'd let you move the date, but I don't think Judge Washington would like me to do that for her. If you contact 14B, I'm sure they'll be more than happy to give you another date.
Perfect. Thank you, Your Honor.
Sorry for my flippant answer. It's getting late. All right.
Always good to see you. Thank you.
Thank you, Your Honor.
Thank you, sir. And next time, just pull over, man.
I will.
Right.
Hopefully there's not a next time. So.
See, that's the better
true.
answer.
Hopefully
That's the better answer.
All right. Take care, guys.
All right. You too.
Thank
you.
Court calls the case. People versus Aaron Wallace.
Did you get permission to leave the state?
Good afternoon, Your Honor. Philip White on behalf of Aaron Wallace.
Your name?
Aaron Wallace.
All right.
Your Honor, we're requesting a short recess or a short adjournment to further plea negotiation.
Further plea negotiations?
Yes, Your Honor.
9th work or the 16th? Which
16th, please.
Which one?
16th, please.
Of course, defense attorneys would always take the 16th. April 16th, 2026, 9 a.m.
Your Honor, we have one additional request. My client is going on taking his 5 children and his spouse to Florida and would request and ask if you would allow him to leave the state 331 to 46.
331 to 46.
Yes, please.
No objection. Defendant may travel to the state of Florida. So what?
331 to April 6 covers.
31 to April 6. You're not going to see that mouse, are you?
No.
Good. Go there, see the duck. It's much better person. All right.
Wait.
Thank you.
Thanks.
Take care. All right. That's that. Set my 3 o'clock clock, but I should take a break.
You should.
I've got that motion. Does Mr. Armadale have the motion?
Mr. Amadeus.
Is that the advice?
Pardon? And then, are they back?
They are.
Yeah. Okay, give me 10 minutes. I'll come out and take care of you guys. Thank you. All right. About time.
State of Michigan, now back in Simpson, the Honorable Judge J. Cedric Simpson.
May be seated. This is Mr. Yes, okay. Court does call the case of the people versus Marquise Johnson.
People here.
Good afternoon, Your Honor. William Amadeo, P76194 on behalf of Mr. Johnson. He was in holding, Judge. You state your name for your judge in court, please.
Marquise Johnson.
All right. Okay, what are we doing?
Your Honor, we're going to plead guilty to the bond violation and ask to set this for the prelim on April 7th. That date's available. I'd like to be heard on sentencing for the bond violation if appropriate. I do think this matter may get resolved, but I want to set the prelim date as soon as possible, please.
So he's admitting to the violation.
Yes, sir.
Discovery is complete.
It is, Your Honor.
And people have their witnesses available to 7. Set preliminary examination in person, April 7th, 2026, 9 a.m. before me. All right. And yes, as to
He's guilty of the bond violation, Judge. He has served 3 days. I'd ask you to consider time served in an alcohol tether. He is working 2 jobs. Obviously, he should turn himself in sooner, but I think he's learned a lesson sitting in jail a couple of days. He can get his jobs back if he's released. I think the alcohol tether would prevent any further hiccups.
any response from the people?
No, Your Honor, please.
He's been in how long? Put him in when?
3 days, right?
3?
Yeah, Tuesday when today's will be the 3rd day, Your Honor.
Usually you do a minimum of 7. You understand that, young man?
I do.
I'll sentence him to 3 days credit for the 3 days served. Defendant must be placed on a scram tether prior to release.
Thank you, Judge.
I'll reinstate his previous bond. Must be placed on a scram tether prior to release. Good. All right. Thank you, folks.
Thank you, Judge.
All right. No. Nice. Court does call the case of the people of the state of Michigan versus Jerome Adams.
And Assistant Public Defender Nicholas Buckovich on behalf of Mr. Adams, Your Honor. Mr. Adams, when you get to the podium, can you please state your name for the record?
Jerome Adams. All right. This is PCC, but also your emergency bond motion. Go ahead.
Yes, Your Honor. As it relates to the PCC, I did never have an opportunity to speak with my client about the underlying case. We just got the discovery very recently, as we were appointed last Friday, and we still do not have media discovery. So as it relates to the PCC, I would be asking for an adjournment of that court date to also have time to go over that with my client. And as it relates to the emergency bond motion, I would be requesting that the court consider granting a personal reconnaissance bond with a tether or a $10,000 10% bond. At his arraignment, there were several bond conditions set, including do not leave the state of Michigan, do not commit any crime, no contact with the alleged complaining witness, and no go to the alleged complaining witness's address. All of those bond conditions, my client would be able to follow. He does have alternative housing. His main concern about his housing at this time is that he did receive a notice of a potential eviction proceeding. It has not got to the point where it has been brought to the court yet. However, he would lose the opportunity to address that matter, particularly as it relates to his Section 8 housing, but payment not being covered in the rent.
You want me to speak?
Oh, no, you're good. Also addressing some other matters, he is the primary caretaker for both his mother and his brother. He actually does have a court date set to obtain guardianship over his brother, who unfortunately suffers from bipolar disorder and schizophrenia. That court date is on April 2nd in front of the 22nd Circuit Court. I did provide when emailing Ms. Wielding the notice for that court date as well, and that's labeled as Exhibit A. And my client does have full-time gainful employment. He will be working through a restaurant as well as a temp agency, and he actually resides at the Glenkill Hills apartments, which are literally within, as indicated in my bond motion, walking distance from the 14A1 District Court. This is slightly down the road on Washtenaw here. So based upon my client's living situation, as well as the situation with both his brother, and I would believe his ability to comply with the bond conditions as ordered by Magistrate Bravery, I would request that this court consider a personal reconnaissance bond with a GPS tether, or on the alternative, a $10,000 10% bond.
Response.
Your Honor, at this point, I'm going to object. This case occurred on or about March 6th. In this case, the victim contacted police from her locked bathroom. She informed police that the defendant had just assaulted her. She was not sure if he was still in the residence, but was too afraid to check. She informed officers that she received a text from a friend that day before all this happened, and the defendant made her call the friend so you could hear their conversation. After this, the defendant approached the victim and began to strangle her. She described the strangulation as an incident where the defendant wrapped his arms around her neck and applied pressure, and then while he was also doing this, he took his other hand, pinched her nose closed so she could not breathe. She then told officers that she was then put face down on the bed and smothered in a pillow. Officers, when they arrived, observed the pillow on that bed with what they said was her spit from the strangulation and being smothered with this pillow. She had a visible abrasion on her nose and red marks on her neck. She also informed officers that the defendant had taken the keys to her house, vehicle, and work, and was fearful that she had no way to secure her residence and that the defendant may return after this incident. Officers also noted that she had the following indications of being strangled: red marks on her neck, a hoarse voice, soreness to her throat, neck swelling, dizziness, shortness of breath, and lightheadedness. I think at this point, based on the lethality concerns in the facts alone, that bias appropriately said. The defendant also has a previous convictions for a 2003 armed robbery felony firearm, 2023 GDH conviction, a 2023 dismissed FA, a 2023 dismissed firearm possession by a felon, FA, and felony firearm. His previous conviction also in 1999 of the CCW. So at this point, based on the facts of this case and the extreme lethality concerns that people have for the victim, given also the fact that the keys, to our knowledge at this point, have not been recovered, not from the victim, that those keys have been returned, I would have concerns for her safety, and just given the facts of the strangulation, and then multiple incidents of strangulation that seem to have occurred here, or methods of strangulation.
Anything further?
Yes, in response, I do note that the prosecutor has noted several past convictions in her response. Many of those were from 1999 to 2003, over 23 years at those points. 2 of his most recent cases have been dismissed. And I do understand there was a 2023 conviction. However, from my understanding, speaking to my client, that was a case of alleged offense date in 2015. There was an outstanding warrant. It was not resolved until 2023. Whenever my client has been on bond in the past, he has indicated to me that he has followed all bond conditions and had not received any bond violations. So, and my client has indicated that I understand there is an allegation that that the keys were taken from that apartment. I cannot substantiate that allegation. My client has indicated that he did not take the keys. So at this time, Your Honor, I would still be requesting that.
I'm not even entertaining anything. I mean, if those are, That doesn't make any sense, but even if the keys are, well, my belief is, I don't think she says doesn't have the keys. He knows where those keys are. That's the first thing. Second thing is that I think the actions in this case aren't, yeah. The bond that is set, given the allegations in this case, I believe is appropriate. Further, the defendant, and I believe what he told counsel, but I checked prior to coming in for the motion to make sure it hadn't recently been filed. But counsel indicated there is no housing case filed.
Not at this time.
There is, even if he was arraigned on like March 20th, the cold-hearted reality of it is if it's Section 8, he's entitled to a 30-day notice. So nothing's going to happen until the 20th of this month of April. And then after that, the first hearing where his housing might be in jeopardy would likely occur, because it's here. So it would likely occur at best May 8th. So he's not in jeopardy of losing his housing. I realize, counsel, you were putting forth what your client said, but he knows darn well that he's not in jeopardy of losing that, nor his substance. Because I consider the defendant to be a danger to the community. Bond was set appropriately, given all of those factors and concerns. The motion for bond reduction is denied. But bond will continue. Thank you.
Understood, Your Honor.
You're also from the record to media, I had one RN was sent over on March 23rd, so I believe it should be open.
All right, very good. Thank you.
Sorry.